The following is a great conversation about politics. It is not indicative of the viewpoints and standards of anyone's employer. Just thought I'd let you know. What's up, everybody? Mikey Famine. We are back from hiatus and just in time for the holidays. The Supreme Court has detonated the earth. You're welcome. Say you guys, patreon.com/the. We have more to speak on. Guys, I am joined with Attorney Anna and Harry. This is our grand unveiling. We've been working on we've been working on their show behind the scenes. Really ready to reveal them just yet. You guys weren't ready yet, but unfortunately, the Supreme Court has forced my hand, and I needed legal experts in this time of dire need and desperation. Anna, Harry, thank you. Welcome to the network. And are we doomed?
Yes.
Goodbye, everyone. Patreon.com/TheBinPodcast. Have a good night.
Pretty solid stuff.
All right, we're out of here. See you guys. No. But Harry and Anna, if you guys want to introduce yourselves, say what's up. This is everyone's first seeing you on the network.
I'm Anna.
And I'm Harry, and nice to meet everyone.
We're lawyers, basically. We have a show. Mikey is going to plug it. It's called The Culture Under Review.
I'm Harry. You'll see us more on the network at a later date, but here we are to talk about the recent Supreme Court Chevron overturning.
Spoiler alert. Very crazy stuff right here. Like, we don't even know what's going on. We're lawyers. It's been going on the same for a very long time. Now it's not. Y'all have to understand this is a lot.
Look, Anna, you can't go around trying to trigger the snowflake libs, okay? I don't need your exaggerating that this is some big deal. Like, I know how y'all liberals...
Let me tell you what. Let me tell you who said it was a big deal. The justices on the Supreme Court. If you can't believe me, believe the Supreme Court, because they wrote, "With fear for our democracy, we dissent." Normally they say respectfully. Fear for the democracy is a twist, for sure.
May the force be with us.
I think the biggest thing is that Anna is simply saying is that every norm and tradition that even as lawyers, as law school students, that we have learned that was once known no longer exists. And I think
we don't know what's on the bar. And sorry to all the law students. Sorry to interrupt here. We have no clue what's on the bar. None. Go on. Sorry.
The bar is now immaterial. It's there. I don't know.
No, for real. They put out a statement like, we're gonna test y'all on the stuff y'all did learn. That they literally are saying that. Basically, we've developed these questions 3 years ago. That's what happens when you follow precedent. They like, we don't know what that is. We don't know her. The bar is what, at the end of this month?
July 25th, 26th. Well, whatever the
so bar exam season is upon us, and this is what the Supreme Court has ignored every norm everywhere.
So to Anna's point, in law school, you learn about very important pivotal cases, and you have what's called precedent, and then you have what's called super precedent. And there are certain cases that are so landmark, established, well, at one point in American history, that you just knew that this is the legal doctrine that you would teach. This is how you would show attorneys out into the real world for their legal practice and whatnot. Some of those cases, Roe v. Wade, Chevron decision, Board of Education.
What's like a loose definition of like precedents, and then you said super precedents?
So technically, the actual definition is really based on how the judges come down. So if it's a 5-4 decision, that's essentially precedent. So, and essentially what that is that, yes, it won, but it won by a very slim margin. If it's something like a 7-2, 8-1, or 9-0, that's considered super precedent. When you think about it in layman terms of how it kind of gets explained through legal scholars, legal pundits, things of that nature, super precedent starts to become things that are so established law that you really don't really need the legislator to kind of enact on because the case kind of speaks for itself. So something like Roe v. Wade, that was the law of the land for so long in terms of women's reproductive rights and a right to privacy and access to a certain kind of healthcare, i.e.,
Right.
abortion. That will be something that was a 5-4 decision, which is precedent. But because of how established and ingrained it was in American history for so long, you would consider it super precedent.
Just to add to that real quick, there's a concept in law called stare decisis, which means it's decided. And a lot of law is built on the fact that once a court makes a decision and that
Great
is the
point.
outcome, we're going
Mhm.
to continue to follow this line of thinking. So as a court, we can advise the country uniformly. We're all on the same page.
Right.
This judge has decided if it's gone up to the high courts, that's the end of it, and we're going to keep following this.
Because then if I get pulled over in city A and go to that traffic court for something, but then I go right next door and it's the same, and then I get, like, let's say it's
So, like,
let's say it's something like having a red car, and then in town B they made it illegal to have a red car, and if I drive from town A to town B, how is it legal for one place and not for another place?
so I see where you're going,
Just so
but
that there's some sort of uniformity, so that you're not getting
Not the
charged for the same thing everywhere. You know what I mean?
not in the outcome in the decision making process. We're going to analyze these the same, but they might not have all the same outcome.
Okay.
so I'm gonna take it a different way than where she took it. So I see where you're going in that sense. So essentially, the idea of stare decisis, precedent, super precedent was the idea that we live in such a big country, and if something is happening in Washington, it could be happening in Alabama, that could be happening in Texas, that could be happening in New York, and now every single jurisdiction is speaking on it differently, and so you have lawsuits that essentially will happen, and it works its way up. What the idea of Supreme Court decision historically was supposed to be that the high court is going to look at the landscape of what everything is going on there, render a decision, and based on the rendering of that decision, Congress is technically supposed to act and enact legislation to pass it into law. What it has become is that because the courts and Congress is so polarized, is that they're never going to agree, that you never technically get to that point. But the point historically was that after the Supreme Court spoke, Congress was essentially supposed to be like, okay, this is the will of the people and what they are saying. Let's write this into law and let the people be heard.
And that's exactly what happened.
Says no one ever.
Except it didn't.
Says no one
And
ever.
that's the cliffhanger, except it did not go in the way that we just described. So all of that was for nothing, everyone. And why did you have your listening ears on in the first place? That's how we feel about our degrees, kind of. It's like, why did we spend all of that time doing that and writing these papers when y'all was just going to decide to be like, you
Or-
know what?
Or maybe not.
Not anymore.
Or maybe not laws.
So
But that is a great point to the Chevron decision because the history of Chevron.
what's Chevron, Harry?
So thank you, Anna. Great
It's
question.
Harry be jumping
gas.
ahead like everybody's smart.
Yes.
It's
no,
We have to keep up,
gasoline.
and viewers, y'all got to stay sharp on this show because Harry
the
might,
gas
he
station that
might
I
leave
fill up
you.
my
He be like, "What
F-
happened?" He
when
be
I-
like, "Oh yeah, you would have caught with."
When I fill up my F-250 with diesel, I always go to the
ideas.
Chevron.
Yeah. No, great question. So Chevron was it was a very landmark decision in the United States at the Supreme Court, and it pretty much stated that the federal courts must defer to government agencies' interpretation of a law or statute, kind of when permissible. So the case was considered Chevron versus natural resource, but the doctrine that came out of it, the legal principle as we would call it, it's called Chevron deference. And it consisted of a two-part test that when the U.S. federal courts had to kind of defer to government agencies to answer certain questions.
Two
So
prongs,
the first,
one would say, legal. Two
yes.
prongs. Ah.
Okay, Law and Order.
So the first question was, has
Let's
Congress
see these
directly
Annalise people.
spoken on the issue at question? So to our earlier point, Congress is supposed to be the legislative body that passes and writes the laws. And so the question is going to be, when a U.S. federal court is rendering a decision based on interpretation, has Congress spoken on this issue? If it's a yes, then we're going to defer to Congress. If it's a no, then the second question is, does the agency answer, is it based on kind of a construction of the statute? Does what they want to do make sense in accordance with how the statute was created? So, just to give you guys a little bit of background of essentially even how we got here. So, everyone would kind of know both the Clean Air Act and the EPA.
We do not know the Clean Air Act or the EPA.
I know
Okay.
all
Why would
about
he
the
even
Clean
say that
Air
about
Act.
He said everybody would probably know them. I'm like, never heard of her.
When they got rid of all the carburetors out
Does
of
she
my
know
car,
Flint, Michigan?
they
She
started
may
Okay,
not.
so
rejecting
everyone
all of
knows
my
that we
Ford
are,
motors.
everyone knows we are in a state of global warming. What everyone may
Everyone does
not
not
know,
know that.
That is a hoax, according to some.
what everyone may not know is that the pollution actually used to be far worse in terms of smog and things of that nature due to the a mass amount of trains, boats, things that were coming,
The
the
cars
imports and
themselves.
exports. And so because of that, various countries, including the United States, passed various acts, one being the Clean Air Act of 1963, which set up certain regulations and parameters
Can
so
I cut
that we
in real
could,
quick?
yeah.
You know, when we set that up after Earthrise, when the astronauts were coming back over their orbit of the moon, and then they saw the Earth come up. After everybody saw that picture, the EPA was like 2 weeks after that.
Oh, because it was so dark, the
'Cause it was
smog.
well, well, no, because they saw how
Oh,
precious the Earth was, and they said we have
oh,
to preserve it. So then they started cleaning up the Earth, and we had the first Earth Day a couple of years after that.
I'm gonna be honest, that sounds like a lie. Anything that's altruistic in nature, that's coming
It's
from
just so
this
beautiful.
government, it was just so beautiful. We had to clean it up. Y'all ain't never
They
said nothing
also
about
were.
nothing like that unless y'all was stealing it.
They also figured out that the doctor shouldn't have told everybody that they should have this brand of cigarettes after dinner. So we were figuring a lot of shit out back then.
That's what I mean. I don't believe it.
They were
I
smoking
even
in the
so
house, and they're like, "Wait, some of this shit's outside." Like, oh no. Apparently, we can breathe
I'ma
that
just
in.
I'ma just
okay.
tell you what.
So
Statues
back
who
to
get
the
acid
damn
rain.
Clean Air Act of 1963. So
Okay, Abraham Lincoln, like you better get back on your soapbox.
4 score and 2 points ago.
He said back to the eat. What did he say? Back to the Clean Air Act. We're listening, Professor.
Shut up, Anna.
Professor. Professor.
So we have two acts that for the purposes of the case were important. So you have the Clean Air Act of 1963. So as we all know, Congress is very ineffective. So through their ineffectiveness, they really failed to really define what considered a source of air pollution was. And so that became an interpretation for individual companies and essentially to define what that was. And so then you had such a landmark case that what is the idea of air pollution and how can we go about either regulating it, defining where it comes from? So in 1981, the EPA changed its definition. Where's your face?
I am confused.
On
Confucius.
So, just to can we do a recap before we move
Sure.
on to 1981?
Real, taking it back.
Okay, so just to make sure I have it right.
Yes.
Back then, pollution was going on. There was a question about how the law says we're supposed to clean this up. Yes.
The law, no.
How to
The
measure it.
question, the question was what was considered a source of air pollution. Not everything that caused air pollution was considered a source of air pollution.
Got you. So they was trying to be tricky with them words. They
Yes.
said, we're not part of it. Y'all trying to get us in trouble. They said, you're absolutely part of it under the law.
Yes.
It's just
Why you just didn't say that?
It's just the
I'm just kidding. We back to 1981.
No, bitch. In law school, you used to be able to explain shit in layman terms. So I appreciate you being like, let's bring it on back.
I'm like, so exactly where are we? But I know where we are. Y'all was polluting the air. Some people said we not polluting the air, and they said yes, y'all are. They said we're contributing but not polluting. Okay.
So essentially, in 1977, it was more broad. In 1981, after Ronald Reagan became president, he narrowed it.
Oh, so people changing the definition.
Yes. And then in 1984, that is when the landmark decision of Chevron came out.
Because people are changing the definition, we don't know what it means, and y'all gonna try to find me and my business for contribution, but no pollution.
I'm sorry. What am I guilty of exactly? Can you define what I'm guilty of, please?
They saying you're a source. All sources gotta pay,
Just
and you
because
like
I have a subscription to the source, and I got 5 mics on my last freestyle.
And I'm actually like, glad you stopped me. Because I'm finna like do a different like take. So this is how we're gonna start it out.
A different take.
No, this is great. So Anna made a great point because she was getting a little bit lost and confused in the sauce of what I was saying. And so,
you was 7 years ago on your soapbox is what you was doing.
And so because of that, we kind of had a little bit behind the scenes conversation. And I think this is the basic way to explain essentially how we got here. In 1963, Congress passed an act called the Clean Air Act. And what that act did was it required any project that would create any major source of air pollution to go through kind of a very elaborate approval process through the EPA that was called a source review. And so at first, with the EPA, they defined the word source in a very broad manner. That would include any building, a machine, a boiler, a train, a plane, an automobile. Think about it. A bucket
of oil.
As we've seen now,
your hair burning in your flat iron.
Air pollution, synthetic. You could be a part of global warming. Remember that, women.
Now you polluting the environment.
As we've all seen that when presidents change, policies change. So then we have a few years later, you have Ronald Reagan becomes president, and through conservative policies, he kind of goes into the EPA and he changes the interpretation of the word source. And he only wants that to mean to include an entire plant or factory, not any individual building or machine. And so under this new interpretation, it reduced the restrictions and regulations, as we've seen through different presidents, how they would change different meanings, laws to reduce regulation. Right. And so now we have the infamous Chevron case and how that came about. And it's because due to the lessons and regulations, you had different various parties being affected. And so Chevron happens in 1981, and then the landmark decisions come out in 1984. And it essentially stated that you have to defer, federal courts have to defer to government agencies for the interpretation of the law. And then, as I explained earlier, you go through the 2-part test to determine how do you go about it.
Why do they defer to the agencies, Harry? Did they say?
You better put me on blast. Why?
I thought you had, hell, you explained it so good. I thought you had one last answer.
You had her convinced you.
I feel like that's more of a speculation than I guess I could say.
Several speculations later. And we're back from those great ads from people who owe us lots of money, probably. Speaking of people who owe lots of money, probably, where were we on this whole DEFCON effervescence.com? I was listening.
So, to recap, for those of y'all in the same camp as Mikey,
No, a camp that
Harry
is. You know what
Harry
camp that
was
is.
explaining that basically, I ain't gonna say a fight. This is how you know you finna get a different version. A fight broke out.
There was a firefight.
Basically, the government said people can't be polluting, and we have a test to see who's a polluter. Uh, the EPA sounds like they expanded it to include a whole bunch of people. The presidents came in and said, "No, not that many people." And then there was a question of whose way is right. Did I do that right, Harry?
Absolutely. And $1 billion question that I want you to answer is
Oil spill.
why are we deferring to the government agencies?
I don't know.
I
The
know.
theory that I have, you know, Mikey?
I do know.
Okay, go
Um,
on.
Because their little brothers owe us money. And this is the best way for them to pay us back through service, overtime.
Yeah. I feel like if you a law student, this is a good question for you to go figure out why. We learned this a long time ago, but the point is, uh, it don't matter why, because we in the situation we finna tell y'all about today. It does matter. I just don't know the real answer. My hunch is that there was some level of the judiciary recognizing that Congress allows power to flow through the executive branch, which the president sits atop. The president is able to control policy in this country by appointing agency heads. Those are secretaries. So, Secretary of Transportation, Secretary of Education, Secretary of
What
Defense.
about the czars?
And
Remember when we had czars?
kind of,
That was great, wasn't it? The czars.
I don't think so. But we finna find out probably. So I
About to
don't think
have
it
all
was a good
kinds of
time,
new
but it
titles
seems
running
like we
around
we
here.
all finna be in new
A bunch
territory.
of German
Um,
titles.
so I think that that's the reason why is because back then the judiciary recognizes that Congress allows this kind of power. The branches have worked together in this way. The president can enact through executive power their own policy to tangibly impact the country through appointing their czars, JK, their
So
secretaries
so let me cut
as
it.
agency heads.
So let me
One
cut.
second, Mikey.
Oh,
I think I think to further illustrate to Anna's point, I think the bigger part is in terms of how she says Secretary of Education, Secretary of Defense, is that majority of the people that work under them are regular governmental employees that will work and live every each day. They're not appointed by
They didn't work there 30 years through
yes,
all
they're
the
not appointed
presidents.
by either a Democrat or Republican.
I've
They are
I
typically
even worked under
subject
Ford.
they're typically subject matter experts in their particular field. And so it's that we're relying on them because they are the experts. They know what they're doing, and they really don't have a political stake in this, i.e., how we got here in the first place with Ronald Reagan changing what was considered the definition, defining source of air pollution in that way.
But didn't a lot of those like heads of departments, they would stay through multiple administrations. So they weren't like necessarily biased one way or another or leaning in one towards one faction or another. They were more or less professionals in a field and kind of get put into this uh, almost what's that bureaucratic role of like a division manager.
The idea behind the framers was that two function of government, or at least one, could really break. And because there were three that were supposed to be independent but co-equal, that so if you had a mad king, just like they had a president
King
here,
Harris,
you
Trump.
still had the ability that Congress could step in and the judiciary could step in. What they did not anticipate is that you would have essentially one party between the branches kind of having this concerted effort to be on the same mission. And I think
Yeah.
in hindsight, that feels very naive.
The Supreme Court is the only branch that mattered because it can turn the
I
other branches.
No, the
it's
legislative.
No,
It was
Congress is the most
because it was
important
from every
between the
single place. And
branches.
so that was like, why the fuck would somebody from Utah know somebody from Hawaii kind of deal in that regard? It was no, Congress was where the shit was supposed to be.
Congress is where it started, but like
Yeah.
Marbury versus Madison was the
Mhm.
first time, and they're kind of comparing this case to Marbury versus Madison, but that was the first time the judiciary took power from Congress to be like, we have review to determine what's constitutional
Animate
and
our
not.
common law outline. I didn't understand it, but I remember
Yeah,
thinking
that was
first
the
day, I will
that was
never
like the
forget that
and
shit.
look at
Never the first
constitutional
day.
law coming in fucking
Literally, I was
handy.
like, I'll
Like
never forget it.
Clutch.
I was like, Anna, I don't understand this
this
shit.
was the main
Anna
shit
was
that I
like,
knew
I
in
got it.
school. This was the main thing I knew. I was
And
like,
she
this
got
thing
me
is
that A.
dumb.
She got me that A. Because I got an A.
I got an A too. It was a good outline, but I made it from the book. So like literally I just started with the table of contents. Anywho, Marbury versus Madison was the first time that the judiciary kind of made a power grab like that, and they basically determined that they could that they had as much power of review that they had, and to render certain things unconstitutional and things like that in connection with precedent and all these other things that are just commonplace to law. This power grab from this judiciary is being compared to that, which was a case out of 1800. So that's like how big of a deal this
From like
is.
1860 something. So
And when you have to go back that
important?
far, it's not necessarily important, but it's just like
I'm
it's
just saying, what was
so
going on? What was going on during that time period?
not the
here's
internet.
thing.
Well, we know what wasn't going on back
Precedent
then.
is
Freedom.
precedent. But I
Freedom
feel
wasn't
like
happening during that time period.
amongst legal scholars, unless you're taking precedent from like 1950, 1960, it feels very outdated and not something that you should take serious. And as somebody who, like, I've had to cite cases when I was practicing traditionally from 1860 something, 1880 something,
When
because
you're citing from when no one knows what was happening, it's
no
like,
other judge had ever spoken on the issue. And I remember having judges taking it as persuasive authority and like, and so Mikey, there's two types of authority. Like you have persuasive, which essentially like binding and non-binding. So if it comes from your jurisdiction, it's binding. If it doesn't come from your jurisdiction and you want to let the court know that another circuit is like doing this and they could follow, then you could show them and they could choose to follow it or not.
But
So I
but
would
they
show
don't
judges,
have to. They're not
right.
mandated
right.
to.
They're not
They can be
mandated.
persuaded
They could
to
be persuaded
take it,
to,
it's
but they're not. But they're
mandatory.
not mandated to.
Okay.
And so I remember showing them that shit, and it was in our circuit, and they still took that shit as non-binding.
They like this shit old as
Yeah,
hell.
yeah,
There have been so many laws since then. The fact that you can't cite anything more recent, what does that actually say about the strength of
yeah. It
your
means
case?
that I should be the first person to speak on this in modern day, and if I want
Right.
to give literally, so
But
that's how.
usually there are laws on damn near
Yeah.
everything. So the fact that you would go back that far, which this Supreme
Or
Court did,
legislative intent, so you can always go to the
you
legislature.
can look at what did Congress
Yeah.
actually say,
Yeah.
which this Supreme Court did, and still managed to
Oh,
come
and
down
ignored the
wrong.
shit out of them, which is very
And
interesting.
ignored them.
Like I
Because
am.
we did actually have this case, a similar case in which the acts of the president were evaluated when Richard Nixon resigned, when they appointed a special prosecutor.
Well, they
These are
didn't
things
answer.
that
They didn't answer the.
Trivia questions.
They didn't answer the Richard Nixon question at the Supreme Court.
they resolved that. I listened to it this morning.
The Richard Nixon question was resolved.
Well, one of the
Oh
questions
yeah,
was
because then they were going to do formal impeachment, and then that's when he.
I was going to say, because then the issue
was.
of whether a special prosecutor
Yeah.
could be appointed was
That's-
like a thing, and also whether firing them, the president firing the special prosecutor as an act of retaliation would be something that they could be, tried for because of the retaliation aspect of it being criminal.
And this is the culture under review.